The ticking time bomb scenario is a thought experiment frequently discussed in ethics, designed to explore whether the use of torture can ever be morally justified under extreme circumstances. The scenario assumes that a time bomb capable of causing mass destruction has been hidden in a city and is about to detonate. A detainee who is known with absolute certainty to possess the relevant information has been captured, yet he refuses to disclose anything. In this situation, we are asked to assume complete certainty that the use of torture would yield accurate information and successfully prevent the catastrophe. This leads us to the central question: should we choose to carry out an act widely regarded as evil in order to save a large number of innocent lives? Human rights advocates typically argue that torture is inherently evil and therefore must never be permitted under any circumstances. However, I contend that in this particular scenario, refusing to use torture would in fact constitute the greater moral evil, because the experiment itself rests upon a crucial assumption that can never hold true in the real world. Hi everyone, I'm Eric, a cat who dreams of becoming a philosopher. This is the place where I share my thoughts and explore new ideas with you all. So, let's dive into today's topic. In the ticking time bomb scenario, the most crucial assumption, one that fundamentally distinguishes it from the real world, is that we are presumed to have 100% certainty that the person being interrogated is not only the genuine holder of the information, but that the information itself is accurate and sufficient to prevent the impending disaster. It is precisely this assumption that completely alters the moral status of torture within the scenario. In reality, torture is regarded as an evil because it is highly likely to be inflicted upon innocent individuals, or employed in situations where it cannot achieve any legitimate aim. In this thought experiment, however, all such uncertainties are deliberately removed. As a result, the scenario should be understood as morally analogous to an act of self-defense. When a person who is known with certainty to possess vital information chooses to remain silent, fully aware that this silence will directly lead to the deaths of many others, that act of silence itself constitutes an intentional act of killing. The catastrophe could be averted simply by speaking. Even if the bomb were ultimately not to cause casualties, the presence of conditions sufficient to constitute a lethal threat is enough to establish moral responsibility. As with killing in self-defense, causing harm to a perpetrator in order to protect the lives of others is not only morally permissible, but may even amount to a moral duty. Therefore, within this scenario, the use of torture becomes the morally justified option, whereas refusing to use it results in the true humanitarian catastrophe. This outcome is produced precisely by the absolutist position adopted by human rights advocates. However, in the real world, the reason we must not use torture is precisely because reality can never satisfy these conditions of certainty. First, we can never be absolutely certain that the person under interrogation is truly the one who possesses the relevant information. Even when the evidence appears compelling, the possibility of wrongful accusation remains. Once the detainee is not in fact the informed party, torture ceases to resemble self-defense and becomes a stark violation of human rights. Secondly, even if the individual is genuinely involved, we cannot be certain that they possess the information we seek, nor that any information they provide would be accurate. Information may fail due to faulty memory, misinterpretation, or third-party interference. In such circumstances, torture cannot possibly achieve the aim of saving others and therefore loses any claim to moral justification. It is precisely because this thought experiment differs so radically from reality that it possesses its philosophical value. Many philosophers and legal scholars who regard themselves as defenders of human rights harshly criticize the ticking time bomb scenario on the grounds that it cannot occur in the real world, and some even accuse it of providing a dangerous justification for torture. However, this attitude is itself equally dangerous, and may even be said to cause substantive harm to the very idea of human rights. Any system that cannot operate in a consistent and predictable manner across all conceivable circumstances is, in fact, an incoherent system, nothing more than an arbitrary collection of values. even if certain situations are extremely unlikely, or indeed impossible to arise in reality. The moment our moral judgment of torture wavers or becomes contradictory in such extreme cases, what should truly be questioned is not the realism of those scenarios, but whether our understanding of torture itself is fundamentally flawed. If our conception of torture is sound, then even when confronted with extreme scenarios that could never occur in practice, we should still be able to reach conclusions that are coherent and rational, rather than evading the issue by dismissing the scenario altogether. Relying on a flawed understanding to determine what constitutes the protection of human rights does not, in fact, guarantee that rights are genuinely protected. It may even unintentionally lead to the violation of others' rights. For this reason, excluding any discussion of the moral permissibility of torture in extreme circumstances, simply on the basis such scenarios are unrealistic, not only fails to advance the protection of human rights, but actively weakens the moral foundations upon which the rejection of torture is built. Contemporary society's understanding of torture, although unable to provide a satisfactory response to extreme thought experiments such as the ticking time bomb scenario, is nonetheless widely regarded within most legal systems and public discourse as sufficiently mature and functionally adequate. As a result, it is often assumed that there is no need for serious re-examination or revision. Yet it is precisely this apparent stability that reveals the underlying problem. A definition that fails to cope with extreme cases is not necessarily a correct one. It may simply be a definition that has never been genuinely tested. Upon closer inspection, existing definitions of torture reveal fundamental flaws, most notably excessive vagueness and a lack of practical operability. Take, for example, the definition of torture contained in the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Under this framework, torture is defined as the intentional infliction of severe physical or mental pain or suffering by a public official for purposes such as obtaining information, punishment, intimidation, or discrimination, while excluding pain or suffering arising solely from lawful sanctions. At first glance, this definition appears comprehensive and demonstrates a strong commitment to human rights. In reality, however, it comes close to failing to define the boundaries of torture at all, because it offers no objective criteria by which such acts can be assessed. This definition relies heavily on two key elements: the subjective intention of the perpetrator and the degree of suffering experienced by the victim. Yet neither of these elements is verifiable or consistent. Intent cannot be directly observed, while experiences of pain vary enormously between individuals, cultures, physical conditions, and psychological states. The result is that the same act may be classified as torture in one context and as lawful punishment in another. Consequently, rules prohibiting torture not only fail to prevent it effectively, but may instead grant those in power an extensive margin of interpretive discretion. More seriously still, attempting to impose an absolute prohibition on torture on the basis of such an imprecise definition leads to a logical dilemma akin to the Barber paradox. When the punishment for torture itself involves the infliction of severe suffering, it becomes impossible to draw a coherent distinction as to whether such punishment also constitutes torture. The system thus collapses under its own self-referential logic. The ultimate outcome is not the successful eradication of torture, but the institutional rationalization of virtually any form of it. Therefore, if the genuine prevention of torture is our goal, and if we wish to avoid systematic self-contradiction, the task of redefining clearly and precisely which acts ought to be prohibited becomes both unavoidable and urgently necessary. This then raises the question: how should we properly define which acts ought to be regarded as torture and therefore absolutely prohibited? I would suggest first that we abandon the two main approaches upon which current definitions of torture rely, namely, the subjective intention of the person imposing the punishment and the degree of pain or suffering caused. This is not because these factors are entirely irrelevant, but because the continued failure to define torture with clarity demonstrates that this very line of reasoning is fundamentally flawed. Neither intention nor suffering admits of an objective or stable standard of measurement. The same intention may lead to entirely different moral evaluations depending on the context, and the same level of physical or psychological stimulus may result in vastly different experiences of pain for different individuals. More importantly still, even where the intention of the perpetrator is identical, whether an act constitutes torture may vary according to the surrounding circumstances, the power relationship involved, and the position of the person subjected to the punishment. Persisting in reliance upon these two criteria can therefore only further blur the boundary that the prohibition of torture is meant to draw. Rather than attempting to quantify subjective experiences that cannot be meaningfully quantified, a more coherent approach is to shift our focus to the negative properties that lead us to judge a particular act as torture in the first place. In reality, punishment and torture share many superficial characteristics. Both cause suffering, both involve the penalization of individual behavior, and both entail the exercise of power over persons. The crucial issue is not whether pain is inflicted, but whether certain defining features are present that cause a form of punishment to cross the line into morally unacceptable torture. Only by identifying these features can we hope to establish criteria that both effectively prohibit torture and avoid internal logical contradiction. I would argue that the first key characteristic in determining whether an act constitutes torture that must be prohibited is avoidability. Torture is widely regarded as a grave violation of human rights, not merely because it inflicts pain, but because in most cases, the person subjected to it has no reasonable means of avoiding that pain. When an individual is unable, regardless of how they act, to prevent torture from being inflicted upon them, that practice entirely negates their status as a moral agent. Taking the ticking time bomb scenario as an example, the reason torture may, in that context, fail to constitute a human rights violation lies primarily in the fact that the interrogated individual retains the capacity to bring the torture to an end. The moment he chooses to disclose accurate information, the torture would immediately cease. In this sense, the suffering is not unavoidable. It is a consequence that can be terminated by the individual's own action. In the real world, however, there are often situations in which a detainee does not possess accurate or sufficient information. In such cases, even full cooperation cannot guarantee that the torture will stop. Torture then becomes a form of punishment that cannot be avoided through any course of action. And it is precisely under these conditions that it loses any conceivable justification and must be unequivocally prohibited. This reasoning also helps to explain why punishments that are not clearly defined in law come perilously close to torture. When the content of a penalty and the conditions that trigger it are not clearly specified, individuals cannot foresee which actions will lead to punishment, and are therefore unable to avoid it in any meaningful way. To protect themselves from the risk of unknown sanctions, individuals are compelled to excessively restrict their own behavior, even refrain from actions that would otherwise be lawful. The result is an unjustifiable compression of personal freedom. For this reason, the absence of avoidability is not merely a feature of torture's cruelty. It is one of the fundamental sources of its incompatibility with human rights. The second important characteristic for determining whether a form of punishment amounts to torture is changeability. This concept is less immediately intuitive than avoidability, yet it is equally crucial at both the ethical and institutional levels. Even where a punishment appears, in formal terms, to be avoidable, it may still constitute torture in substance if it lacks changeability. This is because an unchangeable punishment permanently locks individuals into a fixed value judgment, depriving them of any possibility of correcting injustice through institutional means. In general, when people assess whether a punishment is unjust, they tend to focus on two questions: whether the punishment is disproportionate to the offense, and whether the offense itself deserves punishment at all. Yet, both judgments are inherently subjective, shaped by cultural background, social values, and personal perspectives. As such, they cannot serve directly as stable institutional criteria. If these subjective judgments are simply embedded into law, punishment risks becoming an instrument by which the values of the majority are imposed upon minorities. To avoid this outcome, I would argue that changeability must be introduced as an objective standard. The changeability of a punishment refers to the existence of clear and practicable institutional pathways through which anyone may participate in altering its content, its conditions of application, or even its continued existence, for example, through public deliberation, legislative processes, or even its continued existence, for example, through public deliberation, legislative processes, or judicial review. Where a punishment possesses this form of changeability, the legal system ceases to function as a zero-sum confrontation. Instead, it allows for a non-zero-sum interaction between those subject to punishment and those who support it, enabling the justification of punishment to be continuously revised and improved. By contrast, punishments that lack changeability are highly susceptible to becoming unquestionable instruments of power and ultimately sliding into the domain of torture. Another crucial reason for properly defining what should count as prohibited torture is the need to prevent the failure of punishment from ultimately leading to the failure of law itself. Law derives its regulatory force not from the assumption that it is always morally infallible, but from its ability to create a shared expectation that unlawful conduct will result in consequences that are both predictable and sufficiently serious. When punishment no longer places meaningful constraints on behavior, the law gradually loses its deterrent effect and, with it, its practical significance. The rise in crime rates in recent years reflects the fact that some individuals no longer fear the consequences the legal system is capable of imposing. This problem is particularly evident in non-impulsive crimes. Such offenses are often the result of calm, rational calculations of risk and reward. Where the cost of breaking the law is too low, a rational actor has little incentive to comply. For serious offenders who have already been sentenced to lengthy or even life imprisonment, once the system can no longer impose any differentiated consequences, the law loses its capacity to regulate their behavior and to prevent them from continuing to harm others while in custody. In such circumstances, restricting punitive measures in a purely formal manner not only fails to protect human rights, but may indirectly infringe upon the rights of potential victims. For this reason, establishing a correct definition of torture is not merely about restraining state power. It is also about ensuring that the justice system retains sufficient and reasonable tools to maintain order. If, while clearly excluding torture, we are able to introduce forms of punishment that are neither imprisonment nor torture, and use them to increase the uncertainty of the consequences of unlawful conduct, the cost of crime can be effectively raised. In doing so, we can restore the deterrent force of the law and, in a broader and more substantive sense, better protect the human rights of law-abiding citizens and potential victims alike. Within judicial systems, certain forms of punishment long regarded as inappropriate or inhumane, such as the death penalty and judicial corporal punishment, are controversial not so much their severity but because of the irreversible injustice caused by wrongful convictions. If a person is executed for a crime they did not commit, and the error is discovered only after the sentence has been carried out, that injustice is beyond any possible remedy. Likewise, once judicial corporal punishment has been imposed, the physical and psychological harm it inflicts cannot be fully reversed. It is precisely the risk of wrongful conviction that strips these punishments of avoidability, thereby bringing them closer to torture than to legitimate punishment. Accordingly, the central issue is not whether these punishments are inherently evil, but whether institutional designs exist that can dramatically reduce the probability of wrongful convictions, or even bring it close to zero. If such conditions could be achieved, we would then need to reconsider the place of the death penalty and judicial corporal punishment within the justice system and within our understanding of humanitarian principles, and to examine whether, under specific conditions, they might serve as more effective deterrents to serious crime. Yet discussions of these punishments often fall into a conceptual trap. the assumption that a person may be subjected to such irreversible penalties immediately upon committing a particular offense for the first time. On the basis of this assumption, even if these punishments possess strong deterrent potential, they are rejected outright because of the risk of wrongful conviction. If, however, we abandon this assumption and instead make recommission of similar offenses the condition for their application, the analysis changes fundamentally. For example, where an individual has been sentenced to imprisonment on 3 or more occasions for theft, their conduct clearly demonstrates that imprisonment has no deterrent effect. In such circumstances, continuing to rely on an ineffective form of punishment is, in practice, equivalent to permitting the repeated violation of others' rights. If judicial corporal punishment were introduced as an alternative, not of retribution, but as a means of protecting the fundamental rights of others, then whether such an approach might better accord with humanitarian principles becomes a question worthy of serious re-evaluation. With regard to wrongful convictions, the probability that multiple convictions for the same offense are all erroneous is, in reality, extremely low. Provided that at least one of those convictions reflects a genuine offense, the eventual punishment imposed is no longer wholly unavoidable, since the individual could have avoided it by choosing not to reoffend. In this way, the punishment regains its avoidability and, as a result, falls outside the category of torture. The same reasoning can be extended to the even more controversial issue of the death penalty. If the law were to clearly stipulate that individuals repeatedly convicted of causing serious bodily harm may face the death penalty should they subsequently commit murder, then the question arises whether, with full knowledge of this consequence, choosing to commit murder amounts to a voluntary assumption of the risk of death. If a person, after repeated acts of serious violence, nonetheless chooses to murder, which can attract the death penalty, thereby placing their own right to life above that of a potential victim, whether this still accords with the original purpose of human rights demands serious reflection. For this reason, reinterpreting and realizing the avoidability of punishment is an indispensable element in striking a balance between the rights of offenders and the rights of victims. What the ticking time bomb scenario truly reveals is not a problem inherent in torture itself, but a misunderstanding of the relationship between human rights and torture. In discussions surrounding this thought experiment, some self-proclaimed defenders of human rights are not, in fact, genuinely concerned with human rights as such, but are instead fixated on preserving the posture of defending them. Such an approach does little to protect human rights and may, in practice, generate new forms of injustice. This is because, in certain situations, the protection of one person's rights necessarily entails the limitation of another's. For this reason, in defending human rights, we must continually reflect on what human rights truly mean, and ensure that their protection does not come at the unreasonable expense of the fundamental rights of others. That's all for this video. If you like this video, please like, subscribe, and comment. Every like, subscribe, and comment are a contribution to solving those difficult questions. I look forward to your joining our discussion and making a contribution to solving the difficult questions. Once again, thank you for your watching. Goodbye!